overview of public trust, we'll talk about leaving a legacy for those that are important to you. We talk about our commonly asked questions within the scope of how can you look after your loved ones through a will, the role of an executor and trustee, what happens if you don't have a will and challenging your will, and how to get started with updating your will. We'll also close off with what happens about decision makings during your lifetime. We're anticipating that this will be about an hour's worth of time, and by the end of the event, you'll have some information to move forward with protecting what matters most for the people or organisation that are important to you. Now, just be aware that if you have any questions, we ask if you pop them into the Q&A rather than the chat stream, they pop up a lot more readily there, and we'll be working through answering some of those questions as we go. And then we'll also have some time at the end to see if we can come off any more of those sides of things there. Today's, as we mentioned, event is a little bit limited in time. So if your question is one that requires more personalised details, we may refer you to our local public trust for some one-on-one assistance, but we'll do our best to cover off as many of the questions asked today. In the chat, I believe we've already got a link loaded in there. Yes, we have, to do with the most commonly asked question, as John indicated, was knowing the fees and charges. So we've got a really easy link there that you can click on to find out a little bit more about public trust fees and charges. So now I'm going to hand over to Kim.
Thanks, Carissa. Hi, everyone. So first slide, you can see here that Public Trust is New Zealand's largest provider of estate planning and trustee services. So basically Public Trust offers 5 core services, which is in the red box: wills, enduring power of attorney, trusts, estate administration and private management services. With the wills, that is looking after everything when you pass away. The enduring power of attorneys is what looks after things for you while you're still alive if you can't do that yourself for whatever reason. We have our different types of trusts, which we won't talk about too much today, but is one of our main products. Estate administration, which leads on from appointing public trust in your will. And we also offer private management services such as a personal assist service if you appoint public trust as an attorney in your enduring power of attorney documents. And also we act as court-appointed property managers for finances as well. So they are our main services. Last year, just reflecting on the wills specifically, we celebrated 150 years of public trust, and we drafted on average about 7,600 wills. Of those 7,600 wills, Public Trust were appointed the executor of about 1,400 of those, and that means we completed the end-to-end estate management for those clients. So even though Public Trust alone are doing about 7,600 wills per year, there is still over 50% of New Zealanders who are known to not have a will. So that's why we're trying to raise some more awareness with these presentations and things as well. So hopefully yourself or your friends and your family can get on board and get a will. So we'll flip over. Thank you. This is over to Carissa.
So let's talk about a little bit more about when you die. What will your legacy be? There are varieties of priorities for individuals. From an analytical or theoretical point of view, they can be summarised as maybe being emotional legacies, social legacies, or spiritual legacies. An emotional legacy is we may want our loved ones to be left with an enduring sense of security and stability. For social legacies, that's talking about that you're wanting to make sure that you're passing on that ability, that gift of social skills, the ability to relate to people in life that sets you up well for success. And for others, there might be a priority of leaving a legacy of their attitudes and beliefs about spiritual matters. From a research point of view, our Public Trust recent research found out that 85% of people prioritise leaving an emotional legacy. That is leaving your loved ones with an enduring sense of security and stability. So just circling back to Kim and mine's reference to the factor that of 50% of not having an up-to-date will, the interesting thing from my perspective was, having been here for about 28 years, that statistic has remained the same. So again, hopefully a little bit of information for you today is helpful in changing that statistic. Kim.
Cool. Thank you. So if it's important to you, you should say it with a will. So what we've found in Carissa's long time here, and I've been here about 10 years, there are generally a top few reasons why people tend to update their wills, and that is usually a relationship change, such as a marriage or a new de facto relationship, or on the other side of that, a separation or a divorce. Also, people update their wills if there is births of new grandchildren or children, and another reason could be you're coming into significant money or assets, such as purchasing something or inheritance maybe. So those are the biggest reasons we find people come in to update their wills with us. Another thing is aging. People come in, they think as you're getting older, you start to think about what happens after you die a bit more. So with your will, it's basically your assurance and your voice after you're no longer here. So it's important to make sure you have a will in place so your wishes that you would like to happen are carried out after you're gone, and the people that you would like to recognise are recognised at the end. So I think there is still quite a big stigma, particularly with Kiwis, that if you don't own your own home or you don't have children yet, that you don't need a will. But that is not the case, because 3.5 million people last year were noted to have KiwiSaver. So you only need a minimum of $15,000 in your own name for you to need estate administration. So if you've got $15,000 when you die, then somebody is going to have to administer your estate, and hopefully you have a will in place. So that's more easily done. With KiwiSaver, it can't be jointly owned. And so if you do have a KiwiSaver, like most New Zealanders, and you're working and you do have over $15,000, it will need to be administered by an executor. It's the same goes as well with insurance policies. Quite often people get confused about insurance policies and whether they are in your sole name, as in you're the policy holder, then that when you die, your insurance policy goes to your estate, compared to if you have an insurance policy in place, but you've appointed a beneficiary to the policy, it means then that it won't form part of your estate. So there are, quite a few independent or sole assets that cannot be jointly owned, and therefore you will need your own will for it to be administered at the end. Another thing is that, so when you have everything joint, it does go to the surviving spouse, but as mentioned, some things can't be joint. So it's really important to have that plan in place so you can have those assets and things go to the right people. It is very expensive to go through the process if you don't have a will, but you do have assets in your sole name, which Carissa will touch on a little bit later. The will as well is a really important place to nominate your wishes, as you can see in the boxes along the screen there. It's a chance that you can leave a gift or bequest to somebody that you love or care about, and that can be something sentimental, like a piece of jewelry, a family heirloom. It can be a place where you nominate someone to look after your pets and things when you're no longer here to care for them as well. You can leave monetary gifts. It's a place where you can leave specific funeral wishes about, songs or cremation or burial, where you would like to go after you die. It's also a place to nominate if you have overseas assets and things as well. We always say that you should have a will in your own country. So if you have assets in New Zealand, you should have a will here for those assets. But if you do have assets overseas, it's good to have a will in the overseas country as well. Your New Zealand will can look after your overseas assets, but depending on whether it's a Commonwealth country or not, it can be more difficult, time intensive and expensive if you have assets overseas, but you don't have a will in that country. So yeah, they are really the main reasons why you should have a will and what you can put into it. Oh, more from me. So what's an executor? You can see here that the executor is a person or organisation that you're going to appoint to carry out the wishes in your will. The executor has the important task of carrying out the instructions in your will and ensuring your legacy lives on. So there are 3 different options when appointing an executor of your will. You can either appoint a professional executor, such as public trust, or like John mentioned earlier, your solicitor. The other option is appointing an outside executor, like a friend or a family member, because they can then carry that role themselves. Or the third option is appointing that outside executor, but then employing public trust service, which is executor assist. And that's where public trust are not the executor. Your outside executor remains in that role, but our executor assist service means we can assist that person with a variety of tasks, and that goes as simply as applying for probate at the High Court, or helping with the whole thing. So they're the 3 types of options for appointing executors. It is a very important role to think about. And before you appoint somebody, if it is an outside executor, it is a discussion that you should have with them. It can be very time consuming to be an executor. It can be very, if you're losing a loved one, you may be grieving, so there is a lot of pressure from that side as well. There may be conflict within the estate, and that could be either a conflict of interest because that executor is also a beneficiary of the estate, or it can be that there's conflict within the family or something that executor will then have to mitigate and handle, which again, if you're part of that family or part of that conflict, that can be very difficult to separate yourselves and wear your different hats. Another struggle maybe of appointing an outside executor is if there are overseas family members or overseas assets. It can be very difficult to deal with assets overseas. Some countries are a lot easier to deal with, like Australia, because they're very similar in their laws to us. But even dealing with the UK, which is an English-speaking country, can be very labour-intensive and slow. So that's something to think about as well, not to mention assets in other countries that aren't part of the Commonwealth. There's other times where somebody may be challenging a will or making a claim against an estate. As executor, you have the responsibility there to listen to that claim and go through whatever process is required, if that goes through the court or not. So yeah, there are a lot of pros and cons to think about when you're appointing an executor. One of the main cons we come across when somebody talks about appointing a professional executor like a solicitor or public trust is, it's going to cost too much. We believe that that's pretty much the only con that we come across if people are deciding, but also you are paying for a service. We've been doing it for 150 years. We're very impartial. We are experts in our area. But also the fees and charges are quite often misinterpreted as maybe a percentage of your entire estate, which isn't the case. So we charge a series of time and attendance and set fees, which are all on our website. They're very transparent. We go through and explain what all the fees are ahead of time, what they could be. We give you updates as you go out through the administration, and we can talk to any of those fees that we are charging. But yeah, when you are considering on who you'd like to choose as your executor, just take into consideration how many things can come up in an estate. Even with the most straightforward or simple estates, there are sometimes curly things that come up that you don't expect. Just one example I'll say is that I had one estate that started in 2018 and only finished up last year. So that's one specific example. We have lots of estates that go on for a number of years, but this one particularly went on for 5 years. And that was wholly due to all the overseas assets and things that we had to attend to on behalf of this client. So yeah, as long as you've got the time to be able to dedicate 5 years, then and that's my full-time job. So yeah, that can be very intense, but also rewarding. Cool.
So I'll just delve a little bit deeper into the experiences and challenges that are faced with estate administration. These can be other things that, in addition to what Kim referenced, there's things like legal interpretation of documentation. It could be a poorly written will. It could be a DIY will, which is again why we're promoting the opportunity where you can do yourself your own will online, but within a good structured environment to make sure it's a good quality will that comes out of it. It can also, one of the common challenges we face is old wills. Are they still relevant? Are they still applicable? What changes have happened that need to be incorporated? There's the legal liabilities that an executor and trustee faces about how they manage the funds they are responsible for, what and how much they sell assets for, and who they distribute it to. It's as you're possibly getting a feel for it, also is an immense volume of paperwork involved. There's probate applications, tax returns, financial statements, and communications to beneficiaries. One of the experiences over time I've noticed with emails now, the beneficiaries obviously understandably want quick answers. So if you're dealing with an estate where there's multiple beneficiaries, you could be fielding a lot of inquiries, and quite understandably you want to answer those in a prompt and timely manner. Transparency is a really important aspect of estate administration. The person holding the role of executor and trustee has full transparency as to their decisions, the timeliness of their actions, and the costs incurred. As John mentioned, it's really important that there's full transparency regarding charges as well. Just as a matter of interest for public trust, we have quite a diversity in that area, which is really good from a customer perspective. So public trust is a Crown-owned entity, so we have responsibilities and transparency all the way through our ministerial accountabilities. But in addition to that, we also have a service which is called the Financial Services Complaints Organisation, who is an independent dispute resolution service, who they will audit our fees and charges and associated activities at no cost to the beneficiaries. So that's an independent source that we can present all of our information for a review to. Hopefully you're getting a feel from what we're saying, how that there's many hats that a trustee is required to wear and responsibilities. They may have a close relationship with the beneficiaries, but they are legally obliged to ensure that they remain neutral. The court has endorsed that and held people liable for that. They need to consider both the needs of the beneficiaries, but they also have to consider the claims that may be made against the estate. One of the things that I've heard over times is some common misconceptions. One of them might be that, oh, if you leave someone 50 cents or if you give them a specific gift of money, they can't contest your will. Not entirely true. There's a couple of main acts that somebody could object to your will under. The Family Protection Act, which says that there is a moral obligation to provide for certain people. It's not anybody and everybody, but it is people like spouse, children, grandchildren, in some cases, stepchildren if you've had a parental role and they're financially dependent on you, and in some cases even parents if there's almost like a role reversal situation where you're financially providing for your parents and they're dependent upon you. To give you an example of one of the situations that is in the public domain of available information, one case that went to court was there was the only child of a deceased was provided about $190,000 of the estate, and her 3 children were left $1 million in a trust fund, and $3 million of the estate went to charity. The deceased did not provide further for the daughter as he had a low opinion of the husband's business acumen and work ethic, and he had previously financially supported his daughter and her husband in an unsuccessful business. The daughter had a home with mortgage and a modest income, and the court determined that a wise and just testator, which is the person that writes the will, so the will maker, should have ensured that she had at least had a debt-free home and a supplementary income. The court awarded the daughter an additional $855,000 plus the funds to clear the mortgage, which moved the provisions which she received into the estate to be about 20% of the estate. This was considered under the Family Protection Act to be a repair of the breach of moral duty. Now, another act that's a little bit less well known that somebody might object to your will under is called the Testamentary Promises Act. Now, that act isn't saying you can have this when I die. It says you can have this when I die if you do this for me. In a very simplistic terms, if you mow my lawns 10 times a year, you can have my lawnmower when I die. A more common one that we're starting to see quite a bit coming through is that, hey, I don't want to go into rest home care. If you come and look after me in my home, I'll make sure that you're looked after. And maybe they came in and looked after you for, say, 10 years and you left them $10,000, they might go, well, no, actually, that's not a fair reflection of the intention of the promise that we entered into. An example of that went to court was that in 2002, an individual had claimed that his deceased promised to leave his farm to her in return for the assistance around the house and the farm for at least 9 years of his life. The support was not extensive, but it equally wasn't trivial. Now, interestingly, the claimant was actually found to have falsified diary entries, which was produced as evidence to advance her claim. The estate was worth at the time $260,000, and the court initially awarded $30,000, but on appeal awarded a further $120,000 because it was felt that the judge placed too much emphasis on the fraudulent misconduct of falsifying diary entries. Another act is the Property Relationship Act. Now, this act is relatively new, and that says if you're in a relationship with somebody, whether marital or not, they have a right to be provided for. The act is actually quite broad. There's about 8 different aspects of identifying whether a person is in a relationship with someone. It might be, are they living together? It may not be that. It may be also to do with, are they deemed in public together as a couple? Do they have shared expenses? Things like that. Now, the law can be, was very broad with this, and it can even, claimants can come from other parties, such as, for example, Work and Income can look and see that maybe they feel like the will maker, the deceased person, has not adequately provided for somebody who is asset and income tested, and they may push that is a review made in that regard. And equally, if you die without a will, they can also be exposed to claims. One of the interesting ones I found was that in one case, a neighbour's children's made a claim against the estate, and their farm, valued at $1.4 million, was awarded to the children because the neighbour had been providing meals and including that person as a deceased member of their family for an extensive period of time. So by having a current will in place, you may not stop challenges to your will, but a current will means that you express your wishes relevant to your situation, and then you have the comfort of knowing that you've made the best possible provisions for the people that you care about. Circling back to the role of executor, I'm sure that you can imagine that any of these proceedings would be time-consuming, stressful. They may impact on personal relationships. So choosing the executor who has the time and expertise is really important. Moving on from this, what happens if we don't have a will? We've touched on that a little bit, but just to break that down briefly a little bit more, as Kim indicated there, that if you have $15,000 in your sole name, then the legal process of probate is required and there is an estate to administer. If there is a spouse or partner, no parents, no children or other descendants, then yes, the spouse or partner will receive the estate. However, if there is a spouse or partner and children or other descendants, then this was the scenario I mentioned right at the beginning of our presentation. The spouse will receive the chattels plus the first $150,000 of the deceased person's assets and 1/3 of anything left. However, the children will receive the remaining 2/3. Now, if there is a spouse or partner and parents, but no children or descendants, then the spouse or partner receives the chattels, the first $155,000 plus 2/3 of the estate, and the parents will actually receive 1/3. And yes, in the situation where there is absolutely no surviving descendants, then we are looking at the estate that passes to the state. An application, as I said, to the court must be made in these situations also. And the key thing with dying without a will is that, yes, it can be attended to, but it will take a lot more paperwork, time, uncertainty, and costs of expertise involved.
Thank you. So, excuse me, we do have an online system now where you can write your own will and enduring power of attorneys online in the comfort of your own home. So previously you had to come in and see us to write your will, but now, yeah, we do offer a platform which is really user-friendly and is quite new and up to date, and you can go on there and you can put in all your assets and liabilities, all your relationships, who you would like to be your executor, and put that in there, which will then generate a will in the background. So the platform is easy to use. There is a online chat function that is available in the portal, which means that one of our trustees, our online trustees, will be able to help you if you've got any questions or you need help using the system as well. It does appeal, we've found, to a lot of the younger generation that haven't previously had wills, and that's because they like the accessibility and the way that they don't actually have to come and see somebody face to face to give their instructions. The cost includes coming in to get your will witnessed at the end of it as well. There are additional services you can purchase with your will, which is like a expert review from one of our legal team, and that's just extra peace of mind if your circumstances are a little bit more comprehensive. We have 3 levels of wills pricing with the online platform: a basic package, a standard package, and a comprehensive package. Starting with the basic as little as $85 for a will, and that's usually relevant for maybe a single person, not in a relationship, or no children, and then goes on up to standard and comprehensive based on your personal circumstances, assets and liabilities and things like that. The portal's really good because you can make changes, log in because you set up an account. You can go in and make changes, come back to it, start it, not finish it, come back in a few more days and add to it that way. So you don't have to do it all in one sitting if you are short on time, but it means you can keep coming back, adding to it and things before you finally sign it off. But yeah, so online, easy to use, and if you click the fees and charges link in the chat website that we put before, that'll also take you to Public Trust website, which is easy to navigate through to find how you set that up.
So what about the big decisions while you're still alive? Now, I know we can't do a raise of hands or anything like that on today's function, but I'm just going to ask you a series of questions just to quietly reflect on within yourself. And I'll explain the relevance of each after that. So how many of you have gone for a walk to a location for lunch or gone for a motorbike ride on the Sunday afternoon? How many of you have gone on holiday and done the tourists go for a walkabout to explore the area? How many of you have done building renovations, good old Kiwi DIY, and stood up on a sawhorse or a ladder? How many of you have done a morning routine? Do you have a set routine when you get up in the morning? Do you use the bathroom facilities, have a cup of coffee, things like that? If you said yes to any of these situations, then enduring powers of attorney apply to you and are important to you. Now, I use these examples as family-related experiences, and I do start to sound like I've got an accident-prone family, but if you think about it, it is quite common in these situations. So for a walkabout or going for a bike ride after lunch, Sunday lunch, unfortunately, my grandmother was returning home from a lunch out, and a car came out of the driveway that she was crossing over on the footpath and unfortunately backed straight into her, causing her significant injuries. For the tourist walkabout, one of my clients, who she asked me to share this as often as possible to highlight the importance of this, her father was just quite simply going for a walk and he slipped on some gravel, and unfortunately just the way he fell, he ended up becoming permanently paralysed and unable to even sign any documentation. For those people that like a bit of DIY and maybe pops a little bit not quite the health and safety using a sawhorse or something like that, I had a good friend of the family who unfortunately stepped up onto a sawhorse, fell onto concrete, and again experienced the paralysis and ended up in rehabilitation in Burwood Hospital with a broken back. The morning routine, which I talked about, the bathroom facilities and coffees, excuse it for being a little bit graphic in this regard, but did you know that the most common area for a person to collapse, have a stroke or heart attack is actually in the bathroom or toilet first thing in the morning? Each of these situations are relevant to somebody young or old. They're not just for elderly people, and enduring power of attorney means information, decisions and actions needed could be immediately delayed without the need for court proceedings. So there's 2 types of them. There's an enduring power of attorney for property and financial assets, and there's an enduring power of attorney for personal care and welfare. If you say, look, I've got everything jointly owned, it doesn't matter to me. Actually, it does. So for an enduring power of attorney for property, again, we're referencing those that have the KiwiSaver. They cannot be owned jointly, so they are solely owned. But also in New Zealand, if you own a property jointly, the land transfer requires that if you went to sell, move to maybe a more mobility-friendly house or nearer to where your partner is rehabilitating, without an enduring power of attorney, you cannot sign on behalf of the other person. So what happens if you don't have an enduring power of attorney? It's a very long, drawn-out process through the court. There's a lot of paperwork to go through. Applications and supporting documents are lodged with the court. The matter is referred to a judge, and a solicitor is appointed to investigate the situation on behalf of the incapacitated person. The judge considers the findings of the solicitor. If they agree, they may authorise the appointment. If they don't agree, they'll summons the parties involved for a further discussion before a decision is being made. There may be multiple people that think they should be the property manager, so they may not agree. And then in this situation, whilst an enduring power of attorney goes for your lifetime, a court appointment will last no greater than 3 years, by which time it needs to be reviewed. And in addition, you have to present your financial records for auditing. It can cost up to matters of even $2,000 or more costs, and that can be very long time consuming. I had one the other day that went through the court proceedings. The family were letting me know, and it was over a year before the appointment could be made. And interestingly, that was in a situation where all of the parties did agree that who should be the applicant there. I just want to highlight at this point that life expectancy for people has doubled over the last 200 years. Statistically, it is clear that we're living much longer, and it's important that we need to put in place the provisions to ensure that we're looked after as well as our loved ones, so that everybody has the ability to carry on. And another important factor that I like to highlight here is that Age Concern brought out a statistic to say that 70% of elder abuse, which includes financial abuse, has sadly occurred at the hands of family members. So it's really important that you appoint the right person to be involved, whether in your enduring powers of attorney or in your estate. The other part of the enduring power of attorney I'll quickly highlight is enduring power of attorney for personal care and welfare. It's important to remember for this one, it can only be enacted if you are assessed as being incapacitated, whereas the enduring power of attorney for property, you have the choice at the time of making the document whether it's effective immediately or only if you become incapacitated. So with a personal care and welfare, they must act in your best interest. There's some certain things like they cannot marry you off or adopt you out or withhold treatment that would otherwise cause you harm. That's just a very brief overview of enduring powers of attorney. We're just going to step back quickly to close off with regarding to the will side of things, and I'll hand over to Kim for this.
Cool. Excuse me. So this is a little bit like what I touched on before about our online platform and how to create your own will from home. So it's just a little video. I think it's about 30 seconds. So it will give you a quick snapshot of what the portal online actually looks like when you go in to create your will.
So to close off this part of the presentation, thank you so much for the opportunity to speak to you. Please feel free to contact us if we can help with your planning. We're located throughout New Zealand and as indicated, very accessible online. You've got the link to our fees and charges and relevant information. And I just wanted to check in at this point to see how we're going with the question and answers and see if there was any you wanted us to specifically do. I'll just check in with Kim now.
Yeah, so Felix has written here, hi Kim or Carissa, what happens if a child's parent dies and the step parent is granted life occupation of a marital home, but then downsizes without distributing the children's share and will not give child any information about where the will is, so the child have no idea what's in it?
Gosh, that's quite a long question. I'll break it down. A couple of things. It really depends on what was in the will. Again, having a current up-to-date will is made that when you've got a will, asset protection conversations is so important, particularly if there's a blended family. So you can have abilities where you might leave it all outright to a step parent or something like that. Or you could make provisions if you own your property, for example, tenants in common, where you're giving the step parent the ability to reside in the home, but they're not actually going to have ownership of the home. They'll have the use of it, for example, for their lifetime perhaps, but it's protected for the child or the children of the deceased. So that's a really good way. It's quite, there's not really a succinct way of doing that quickly. So if you've got any situations where you're interested in how you can make sure that your children are looked after, you've got a blended family situation through the way that you own your property and the way you do your will, do give us a call and we're more than happy to talk through. We've got a really good information sheet that we can hand out on tenants in common. I wanted to highlight there a couple of things also is that when we're talking about guardianship of children in a will, again, it's really important to have that put in your will if you have children that are minors, but it's important to remember that when you're referencing guardianship in a will, it's referring to what we call testamentary guardianship, not custodial. Testamentary is who do you want involved in the decision making, who do your executor and trustees consult with regarding the assets that your children will be provided for under your will. Custodial is a family court matter, so if you've got any issues with that, it's really important to seek some advice in that regard as well. I also wanted to mention within that scenario there, when you do a will, it's that emphasis about who you have involved, who's the consultative people, who's in charge of managing an asset for a child for a lifetime. So you have the ability, as I said, to protect the child's interest, whether it's in part ownership of the property, in the way that you provide for your partners, as well as for a child from a prior or children from a prior relationship. If it's held within a protective means, then the person that is managing that assets is held legally liable for how they manage that. So, for example, when Public Trust is an executor and trustee, and we may be holding assets in trust for a minor in accordance with the will until they reach the age of, say, 18 or 20 or whatever the specified age. That during that time, if there's cash funds, it's available for education, maintenance and general wellbeing. But the decisions about how we hold that fund, how we invest it and grow the asset value if possible, and what we distribute out for and who we distribute out for is actually all the executor is held liable for those decisions. So having the right person to make that is important because, for example, in that case, if the step parent was the executor and trustee of the will and was making decisions that were caused to be questionable, they can be challenged through the family court for their action and could be held liable for decisions that they made there. So I'm probably not entirely answering that. I'm just flagging attributes of that to bear in mind, and that's a blended family is a really good example of where to have a good conversation with a trusted advisor such as your trustee company, public trust, or a solicitor about your individual situation so you can do some comprehensive estate planning.
Cool. I'll touch on this one. So what happens if you don't quite know what to leave, say, an adult child and partner or grandchildren? When's a good time to gift assets to grandchildren? So you've said in the first part you're not sure what to leave somebody. It is entirely up to you what you would like to leave to your beneficiaries. I did touch on a different question. I'm not sure if everyone's seen that, but there are 3 acts of legislation that impose on a will: the Family Protection Act, the Property Relationship Act, and the Testamentary Promises Act. So when you're thinking about what somebody might be entitled to, or how much you should be leaving maybe a partner or a spouse, it's good to look up those acts of legislation, because it will give you some guidance as to maybe who could make a claim against your estate, or what legally or morally you should be leaving that person. When's a good time to gift assets to grandchildren? You can gift things to your grandchildren or children throughout your lifetime, personal effects and photographs, those kind of things, household goods. You can do that before you die if you want to personally give it to somebody. In terms of monetary gifts though, and when's a good time to gift those, you can also gift money during your lifetime, but there are gift limits and how much you can gift in a year. There may be tax implications for it, but also things to consider, such as asset testing limits for applying for a residential care subsidy and things like that. There's a certain amount of money you're allowed to gift up until a certain time before you go into residential care if you are applying for a subsidy. So there are things on the Ministry of Social Development's website about, and also IRD's website, about gifting limits in terms of cash. So yeah, hopefully that answers your question.
One thing I'll just jump in and mention that, because I do hear it from time to time, is, how about I give all my assets away during my lifetime? It's just really important to bear in mind. It gives me a little bit of anxiety when I hear that. You never know what's happening with the person in their life, and not only their relationship, but what else is going on with them. So for example, if you did choose to do that, which is not something that I'm advocating for, potentially some of the challenge you could face is, for example, if they're in a relationship and their relationship breaks down, potentially the assets that originally were yours are exposed to that marital or relationship claim. If they're in business, or they do some work and they're held publicly liable for something, that could be seized and claimed as part of their assets. If your relationship breaks down, what happens then? It's the same as the similarity of if you go in joint asset ownership with somebody or build on a property together. So it's really important, again, you have those comprehensive, independent and impartial advice before you make any of those decisions in that regard.
Cool. John's asked, how does your solicitor or executor discover you've passed and begin to exercise your will? Do you need to give a copy of your will to your children? So we here at Public Trust, we receive or go through the death notices from your local newspaper. So for Paraparum or the Kapiti area, we look at the Dominion Post as well. We check if any death notices apply to our current clients. So we just cross-reference the database in that way. Lots of the time as well, the family member comes in to see us, or the executor comes to see us, or the friend, to let us know that that person has passed away as well. And that's quite often before we get a chance to go through the day's death notices. But we always encourage you to give a copy of your will to your executor, maybe if it is an outside executor, or even just let your loved ones know that you do have a will, where the original is held, and who the executor is, because then that saves a lot of wondering and looking around and things when you do pass away. Also things, if you've got funeral directions that are quite specific or that you'd like to be followed, it's important to let those know, let those family members or whoever's arranging your funeral know what those are as well. I'll give this question to Carissa. If the trustee for a minor's trust is the public trust, what information should the public trust provide to the parents of that minor?
Yes, so that is a good question. When we're holding information on trust for a person that is a minor of age, and once they hit 16, they're entitled to be consulted with and receive information, and then 18 is the minimum age now under the new legislation by which you can then pay out to that child, and it's up to them what they do with it from there, unless you've specified an age in your will. Our accountability during that time is if we're executor and trustee, there may be a guardian appointed, or what used to be called a specialist advisor or an advisory trustee who we're to consult with. So they would be entitled to that information. And we also consult with whomever is the primary guardian of that person, the person that's in custodial care, or unless there's some legalities to do with who is the legally appointed one there. So types of things that we would engage with them about is, for example, if there's monetary amounts, we sit down and do a proper investment review and analysis of how to best manage that money. We'll put forward that investment proposal to them for feedback and consideration. We also will explore with them what they're anticipating the short-term, medium-term, long-term needs of the individual, calculate sort of the age of which they are now to the age of maturity of which they're entitled to have it paid out. If the new Act or the amended Act is actually much broader than previous legislation, which was more a little bit contained to say, oh, there should be maybe 50% left or something, that the new Act doesn't actually say that. There's a much broader spectrum by which the minor or their guardian can apply for the funds for. But things that we would look out for is that what is the dynamics of the situation, because there's a difference between if a minor is living with their parent, maybe surviving parent, or both their parents, because they still have financial obligations towards that child. So maybe it was a grandparent leading funds and trust. It's not the grandparents' estate fund that the children should then be fully funded, because the parents still have their obligations towards their child, depending on obviously the circumstances that may be around and any prior provisions that the grandparent role may have had. And equally, if there's a surviving parent, then it might be that, hey, we pay for the school fees or special education side of things, or they want a contribution of half. So it's a very collaborative approach to work out what is a balanced approach, how much do we conserve so that there's some left over for the child, what was the original intent of the will maker, was it to make sure that as much as possible was conserved so they can buy a house, how long before they're due to maturity. So all of those discussions would be had with the likes of either guardians, advisory trustee, the custodial person, and depending on what the documentation say too.
Cool. Can I ensure that if I die and my husband remarries, my children still receive 50% of our joint property at the point where I died? So in short, no, you can't ensure that 50% of your joint property goes to your children. Quite often we do have a couple married or de facto coming in, they have children and they say they would like to make what we call mirror wills, where the wills are essentially the same as one another, and saying that, you know, when each other dies, they will look after each other's children. We do say that those wills are based on trust at the time, and there is nothing stopping the surviving spouse to update their will and write out their deceased person's children after they die. That does happen. We do see that, unfortunately. There is a way that you can look after half of things, like a big asset like a property. So if you do own a property with your spouse or your partner and you have children together, or a blended family situation, you can own your property in different ways which can protect for your children after you die. And that is, instead of owning it jointly, meaning that you and your partner own it together, and then when you die or the other dies, it passes directly by survivorship, there is the alternative option to own it tenants in common and separate shares. So if you did put in equally, one of you could own it 50% and the other owns the other 50%, meaning that when the first person dies, the 50% they owned goes back to their estate instead of directly to their partner or spouse or co-owner. You can provide the surviving partner a life interest to live in the property for a period of time if you're worried about leaving them homeless, but it just means at the end of the day, when the property is sold or disposed of, that your children will get 50% or whatever share you own. That is protected for them in that instance. do you have more to say about that?
Yeah, I thought I'll just quickly mention there, obviously there is the deeper aspect of family trust, which we won't cover off today, but that's again some individual advice that you might want to explore. It's one definitely to take time and individual advice. The other thing to just highlight there is that if you have a contracting out agreement, or what previously was called a prenuptial, it's important to look at how you maintain that agreement. Over time, it can be very easy, like particularly if you buy and sell assets and things like that, that you might start intermingling assets and in effect changing the terms of your agreement. So it's important to bear in mind that if you do have an agreement, that you continue to align to that and where appropriate, update it. If you don't have one in place and you are bringing together a relationship where you've got different provisions or different asset ownership that you want to reflect and prevent claims either during your lifetime if the relationship breaks down or upon your death, then you might also want to go and explore through a solicitor the option of a contracting out agreement, which used to be a prenuptial.
Hey, Kim
or
and
a property sharing agreement.
Hi, Kim and Carissa. I think we have time for one quick one to answer
Yes.
before wrap up, and then we'll bring it to a close.
Is there one that I've missed that you can see, Felix or Amar? Because I feel like Felix has answered a majority of them. I'm not sure if I've missed anything. Has anyone else got a question?
There is a question there about, is there an extra charge for the chat
Felix
functionality
has
on
no.
the online course?
Felix has answered that one. No,
Okay.
There is no additional charge to use the online chat on our online portal. I think that's it. Oh, sorry, there is one here about a statutory declaration. Oh, sorry, I've lost it. Something to do with is it correct that the enduring power of attorney does not allow the attorney to sign a statutory declaration on behalf of the appointer if the appointer is still alive?
I haven't actually come across that situation. The only the thing that I would highlight, which I'm not sure that's particularly addressing that question, is that please remember that enduring powers of attorney in itself, setting up the document, the donor, in other words, the person making the enduring power of attorney, can only have its document witnessed by an authorised representative. So that's either an authorised solicitor or an authorised representative, such as Public Trust being a trustee firm. So when you do a document, it's not quite the same as a will, where you can get, for example, your two neighbours to witness your will or two friends to witness your will, as long as they're not named in your will. An enduring power of attorney, when you're giving that authority under that document, you can only have your signature witnessed by an authorised representative, such as a solicitor or a trustee firm such as Public Trust.
Cool. Sorry, Amar, I know you said one more, but there is one that we missed. I tried to respond to it in the chat, but it keeps bouncing back and I've asked it again. So I'm sorry, there's no name because it says anonymous user, but it says my next of kin is in Australia. I am an Australian, but have lived in New Zealand for many years. What impact does that have on a New Zealand will? E.g., are there any further documents that need to be in place together with the will when there is no executor or beneficiary in New Zealand? PS, to that question for clarity, my Australian-based next of kin is also to be both my primary bene as well as the sole executor of the overall estate. So I did start to type a little bit there, but basically you can have a will in New Zealand that looks after your New Zealand assets and even your Australian assets. If you don't have an Australian will, you can have a Australian person to be the executor of your New Zealand will, because most things can be attended to online these days, and anything that needs to be originals can be posted. We probably would encourage, if you do have a will where the primary beneficiary is also wanting to be the executor, that perhaps you do think about some level of impartiality, maybe appointing somebody different to be the executor, as if that person is the executor and the sole beneficiary. If there was an instance where there was a claim made against the estate or the will, it could be quite difficult for that person to be wearing all those different hats as executor and the person solely inheriting under your estate. So there's nothing stopping that, but it's probably best to have somebody else that can offer that separation.
Thank you, Kim and Carissa. Thank you to John and Consumer NZ. Thank you for all that attended. For more information on the offer, please go back to the Consumer NZ site, where there is information for you to follow on. We will send out the recording of this session and the FAQs post this session to all that attended and registered. Apologies we couldn't get to all questions, but always feel free to reach out to the Public Trust team and book in a time. Have a great day.
Thanks, everyone.
Thank you.